Various companies seem to be abandoning the COVID-19 mandatory vaccination policy. The recent case being Standard Bank, who sacked at least 40 workers who did not comply with the vaccine policy at the time. Now, last week, the Commission for Conciliation, Mediation and Arbitration delivered several arbitration awards which have upheld the dismissal of an employee, Baroque Medical, who refused to get vaccinated against COVID. The CCMA ruling states that it was unfair and unconstitutional for the company to retrench Kgomotso Tshatshu for refusing to be vaccinated. So what does this ruling mean for employees who've been fired for refusing to take the vaccine? Joining me now is labor lawyer advocate Vusi Masango. Advocate, good morning, and thank you very much for your time and for joining us here on the news feed. AM. I'm also reading in the news that the South African Human Rights Commission, for example, is inundated with a lot of employees who've been fired because of this question of vaccine mandate. Now, in this particular matter that you were looking at, how critical was this very important issue of a right to freedom of choice and the right to an environment not harmful to one's health and well-being? Is that something that was canvassed at length? It dominated this particular case?
Okay, so thanks for the opportunity. And this question of the freedom of choice, basically, one of the rights that is enshrined in our Constitution, was not the only point, but it was one of the points that was argued at the CCMA to say that when companies implement these mandatory vaccination policies, one of the things, or maybe the unintended consequences of such implementation, is that they tend to violate employees' rights that are entrenched in the Bill of Rights. As you know, that the Bill of Rights gives you a range of rights which must not be willy-nilly be violated, unless if they are done in the right way according to a law of general application. And again, looking at other issues like, for example, are there less invasive means to deal with the situation, of which in this topic of COVID-19, we know that there were less invasive or less restrictive means to deal with this stage of the COVID-19 pandemic.
Yeah. Now, do you think the problem started, of course, with those directives issued by the Department of Labor, which are being argued at this particular point, kind of left things in the air, ostensibly meaning that employers had autonomous discretion to enforce mandatory vaccines as how they please?
Well, certainly, most people will view it as that, in the light that people in general expected more out of the Ministry of Labor from the government itself. But now, I think the government considered, and it was correctly advised, that should it pass a law of general application that will apply to everyone, then the chances are that it will pass constitutional muster. You know, it will be challenged at the Constitutional Court for violating the right of the people in the Bill of Rights. But now, going back to your question, the directives and also the Occupational Health and Safety Act doesn't require companies to pass mandatory vaccination policy. What it does is that it puts processes and procedures that companies must adhere to, must consider in order to do what we call a risk assessment. So if I'm a company or an employer, I have a number of employees and I see the relevance of maybe trying to implement one of these risk COVID mandatory vaccination policies, then what I need to do, I need to consider the directives by the Minister of Labor, the Occupational Health and Safety Act, take those directives and do what we call a risk assessment. Now, a risk assessment will cover things like the categories of employees that would likely be affected, selection criteria. It gives you all of those. Then obviously, if you do a proper risk assessment, you should end up with what we call a risk assessment report. Now, that will be your Bible that guides you through if you choose to retrench in terms of operational reasons, then that will speak further to the Section 189 requirement. Now, what happened in this case is that at CCMA, at cross-examination, or at any other point at CCMA, a risk assessment was not taken. It didn't form part of the evidence. It's either it was done, but they didn't want to produce it, or maybe it wasn't done at all. We don't know.
So in order for us to avoid this kind of piecemeal approach where every instance would have to be taken to the CCMA and decided on its own individual merit, as you put it in this particular instance, what would need to happen so that we can have a law of general application that would span across when it comes to this question of vaccine mandates? Because I know that the CCMA arbitration award is not binding as a court judgment, is it?
Well, first things first. The CCMA, let me start with your last statement. A CCMA award is binding. It's final and it's binding. One way that you can deal with it is by, if you are dissatisfied about it, you can take it up on review at the labor court. That's what many companies will do if they are dissatisfied. They will review it. But as is at the moment, an award is binding. You know, the company has to comply according to the award. If not, then that award can be enforced. You know, or you can apply to the labor court to make that award into an order of court. Now, another aspect that we touched on is that how can we avoid to deal with this in a piecemeal fashion? I don't know if we can avoid dealing with such cases in a piecemeal fashion, because each and every case has to be considered on its own specific merit. This thing of trying to come up with a blanket mandatory policy for everyone is not going to work, because not every employee has the same medical requirements or medical needs. That's why it's so important that any employer that contemplates on implementing some kind of a vaccination policy, consultation with medical experts, consultation with GPs, getting medical certificates from employees, it's very, very crucial, because we might be 4,000 of us working for you, but we are not the same medically. We have different medical requirements. You understand? Yeah. So specifically going back to this case of Kgomotso Tshatshu, she went to a doctor. A doctor consulted with her, and a doctor issued a medical note recommending against vaccination. She went back to the employer. The employer outright rejected the medical certificate of the doctor. And bear in mind, this is a doctor that has been treating Ms. Tshatshu all the time. She treated Ms. Tshatshu 10 years back for what we call a bronchopneumonia. Right. Our client didn't end there. The employer actually referred Kgomotso to go to Mediclinic to see a doctor. Kgomotso went, and the doctor consulted with her and issued another medical note that says she is not recommended for the vaccine. Kgomotso went back to the employer. The employer rejected the second medical note. You know. She didn't end there. She went and consulted with a third doctor. The third doctor is the one who, because at that time Kgomotso didn't show any sign of sickness, the doctor declined to issue any medical certificate. So what happened here is that the employer was given medical certificates. The employer outright rejected medical certificates. But what is baffling is that the employer didn't just rejected medical notes, but didn't provide any medical evidence to rebut those notes. The employer is not a doctor. A lawyer is not a doctor. I can't rebut medical notes without consulting a GP to say, look, I'm faced with 2 medical notes from my employee. Can you give me medical notes or medical information that can counteract or rebut or verify this information that we get from this employee. They never did that.
Yeah. So are you saying this in a way is precedent setting to the degree that any employee who has been fired can now challenge that dismissal on the grounds that a risk assessment was not conducted?
Well, certainly they can challenge it, but as we know, CCMA commissioners are not bound to follow the awards of other commissioners. As I've said, each and every case is taking on its own merit. However, if you read this award, it will sort of like guide you as to certain things that you must look at. For example, if you are a company, or again, even if you are a commissioner, there are certain things that you should entertain. For example, a lot that was said on this award of Kgomotso Tshatshu was concentrated on constitutional issues. However, if you have a chance to read our papers, our submissions, our heads of argument, then you will realize that we challenge the dismissal substantively and procedurally. And one aspect, again, that is not spoken of is the aspect of severance pay. When you get dismissed for operational reasons, we call it retrenchment. You should deal with the issue of severance pay. In this instance, Kgomotso was not paid severance because it was alleged that the company offered alternative employment. One of the requirements by Section 41 of the Basic Conditions of Employment Act is that when you retrench, you as an employer, you need to offer alternatives, either by another job, another position, or even different in the terms of employment. In this case, remember the employer, before they even started with the process of retrenchment, while they were still informing the employees, they told them that there's no alternative. In other words, this policy applies to everyone, so the aspect of alternative positions is not there. So there is no way that the employer can say they offered alternative, even if they wanted to, because they had already ruled them out before they even finished the Section 189 process. So the only way that an employee can forfeit the right to severance is if when that employee, one, has been offered alternatives and the employee unreasonably refused those alternatives. Right. In other words, even if the case was that our client had refused the alternative, right, her refusal should have been proven to be has been unreasonable.
Advocate, thank you for that clarity you bring for us this morning. Advocate Vusi Masango, the labor lawyer, was representing Kgomotso Tshatshu in her challenge of her dismissal by her employer. And of course, that is a conversation that continues the debate around mandatory vaccines in the workplace. COSATU taking that up as well.